You were charged of driving while intoxicated. Second offense, you were facing up to a year in jail and or a $4,000 fine. You know, you just heard what I said to this other gentleman here. Life doesn't get easier. It gets a lot more difficult the older you get. And when you start racking up convictions, all you're doing is you're making the life even just more difficult. If you have a drug and alcohol problem, there are ways to address it. But when you endanger other people's lives, you may end up digging a hole that's so deep you'll never crawl your ass out of it. And you'll be stuck like Chuck in custody for the next 40 years. It happens time and again. If you don't believe me, watch the news. Every single day, someone dies from a DWI in our county. Yesterday, a construction worker. Take an Uber. It's extremely easy. They make it so easy that all you literally have to do is push one button. Because I'm going to tell you now, with your history, if you ever get pulled over and an officer smells anything funky, you're going to go down. And this time, it's out of my hands. From now on, you're in felony court. You're 2 to 10 at the penitentiary. Even the faintest smell of alcohol. Do you understand, Mr. Jaggers?
Yes, sir.
Somehow we have to get through to you. Hopefully it doesn't take the fact that you sit there charged with a 5 to life case because you've done something that just you cannot get a clue. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, these will go on your record.
Here's where the math gets real. Fleischer isn't just counting offenses, he's calculating futures. A third DWI in Texas isn't a misdemeanor anymore. It's a felony. We're talking state jail, not county. And notice how he pauses at 31 years old. Because when you do the math, 31 plus 2 to 10 means this guy could spend his entire 30s locked up. The judge is literally doing the life math out loud. Is that compassion or a warning shot? Honestly, it's Bo.
1 and 1 are 2. 2 plus 1 is 3. A third, you're looking at 2 to 10 at the penitentiary. Do you understand?
Sir.
The rest of your life. What are you, 32 right now?
31.
31. You're going to be driving for the next 40 years. How do you plead to the offense of second offense driving while intoxicated? I'm going to find you guilty. I'm going to sentence you to 330 days in jail. I'll give you credit for the 113 days that you've done. I am going to suspend your license for 1 year. Do not drive until you get a license. What do you do for a living, Mr. Jaggers? How much money do you make a month?
0 right now.
I'm appointed to this case, Judge.
So you're working for free? What?
Yes.
I don't know. Well, why would we reward him? He was to obtain a device he just never did.
He doesn't have a vehicle, Your Honor. I was notified by pretrial yesterday that there was this BVR. I talked to Mr. Jaggers about it. He didn't have a vehicle, and by his account, if I didn't have a vehicle, he didn't know what to do. But he's here today.
So you just do whatever you want? I mean, this continue to happen over and over and over. I mean,
He spent, better part of 4 months, 3 months in jail awaiting resolution of this case. He has done that time, Your Honor. He's working now. I really believe that to help him get better, he needs to put this behind him and get started with a new phase of his life.
Mr. Jaggers, I'm going to waive the court costs and I'll waive the DPS fine and surcharge. Just take a damn Uber, man. It's not hard. One button on your phone. All this could be avoided by hitting one button on your phone. All right. Good luck.
Thank you, Judge.
At what
You're a
point
mom?
does accountability turn into routine processing instead of real justice?
You're a mom?
I am.
How are you?
Good morning.
Thank you so much for coming today.
Thank you for having me.
You know, Mr. Hall, so with the 4 open cases, you're lucky to be out. You know, you really need to listen to mom so that a 5th case doesn't occur. It's not going to go well if you pick up a 5th one. Do you understand?
You have to excuse me, I'm sorry.
It's okay.
They're trying to do 2 medicines on him. And it doesn't have him here, if it makes sense. He's listening, but it has him, if you speak, he's dragging. And I'm okay with that because I can control what's going on. As I was there, I work in the business, everything was actually with the one day, the sheriff department. And I work with the homeless. I came out of engineering because he taught me 2 things. I have to pay attention to what's going on home and not just give love to people on the street. It makes sense, right?
That's great. That's wonderful.
Done my homework recently, these big last 2 situations. His grandmother and his grandfather is dealing, they had mental ideations as well. So it triggers, mom says, be careful who you choose, but we can't be careful who you choose, right?
Right.
That was not. So I'm holding on gracefully to this. You have to excuse my appearance. I've been in cold gray.
Oh, please, you look great. But my concern is that please tell me he's living with you?
Yes.
Wonderful. Okay.
As I said, I'm bringing paperwork together to get custodial.
Guardianship. Okay.
To get him placement to stay.
You know, I'm happy to, whatever you need, we're happy to give you. You know, we have a lot of resources here that we can always, you know, try to help you with, you know.
Appreciate you.
All you need to do is ask, you know, if you need tablets, cell phones. We can also do evaluations to see, you know, how we go forward. So I'm all ears and I'm with you. Whatever you want, you know, whatever conditions you think are appropriate, we can put on it.
We just had an evaluation on the,
Is mom's the CW in the cases? Or,
So Judge, these are old cases from what I remember, 2022,
So
the
the-
ID, the trespass.
well, we have one terroristic threat of a peace officer or a judge. Is that right? I just,
okay, this is what happened.
no, don't. I just,
We just did a psych evaluation
okay.
and we were in the room. I hope I.
No, let's not, don't. It's really, it's,
I'll talk about that right now.
yeah, that's something that we can do later. But at this time, I will leave him in your care. Your, whatever you need, we're here to help you out with. The only thing I'm going to ask is just you guys, just please stay in touch with Evita. She will help you out. And I just don't want a 5th case. That's it. I'm with you. So how long do you want to set it out, Kavita?
I think maybe a 6-week, the evaluation, all the medical together and talk.
Okay. Okay. I'm going to waive his appearance. That way he doesn't have to waste his time coming to court, but just be nice. Self-control. All these cases are because of no self-control. You get upset and you wake out. But think, it's okay. We all get angry. We all do. But just think before you act. Think before you speak. That's it. Listen to mom. If you ever need anything, come back and I can help you out with whatever you need. Just say the word. Okay?
Judge, in regards to bond conditions, how did you want to handle that?
So the bond conditions that I'd like is just no contact with ever the terroristic threat cases and just no weapons. That's all I would like. My concern is that it was a healthcare provider, because that's what I was thinking. Is that someone that he's currently seeing? Do you know? Alex, who in the
In the
most recent case, who's the complaining witness?
most recent case, let me see. It says the reporting party.
Oh, that case is upstairs. It's not even with us. I'm
That's on,
sorry.
Your Honor.
So disregard it. I thought it was with us.
Yes, Judge.
So the only condition is just no weapons. That's it. Okay. And just stay in contact with your lawyer. Okay. Absolutely. Mr. Halsall, good luck, bud. All right. Okay. Thanks.
Thank you, Judge. May you be excused?
That is Mr. Riley.
Yep.
Riley, last time he was here, Your Honor, asked him to do some employment, which he's filling out that proof of that.
Okay.
Schooling, I spoke to his mother and his aunt. And the issue there is, he doesn't like the school he's zoned to. It's not a great, fit for him. And so he's trying to get with the aunt, and there's just some logistical issues. But I spoke to both the individuals, and I mean, he's making good faith efforts to do it. He's just has not yet.
Is he here?
Yeah, he's here.
Okay. Ridley, come up. Is mom here?
That.
Who's that?
I don't. Yeah. I spoke to her last night, and she wants to hear. And still next door. Yeah.
Is that mom? Hey, mom? Come on up.
Yes.
Thank you so much for coming. It's great. So what's going on with Mr. Ridley now?
I haven't had a chance to let him do like the holiday work together, but he's looking for a job, and I'm trying to get him back to his house.
So you're not doing anything now? You stay at home and do nothing?
I was.
He's looking for a job.
I got put like 3-4 applications in.
School is more important, Mr. Ridley. You need to get your education, man. You need a high school diploma. At worst comes to worst, we can give you paperwork so you can do the schooling at home and get your GED online at a minimum, and we can give it to you for free. But I mean, you're at home you're not working, you're not going to school, you're doing nothing to make life better for yourself.
Pause this and think about what you just heard. A judge telling a teenager, life sucks without money. That's not in any judicial handbook. Fleischer is doing something courts rarely do, addressing root causes, education, employment, future trajectory. This kid isn't just facing charges, he's facing a life without options. And the judge knows that if he doesn't get his GED, if he doesn't work, the statistics say he'll be back. The ankle monitor isn't just for tracking, it's a countdown clock. 2 weeks. What do you think the odds are he shows up enrolled?
Life doesn't get easier the older you get. It gets more difficult. If you don't have a job, if you don't have an education, you will end up nowhere. And life sucks without money. Trust me. Do you understand? Hey, do you mind giving them the paperwork, please? We need to be somewhere, Mr. Ridley. I'm going to give you another couple weeks, 2.5 weeks. At the minimum, be enrolled to start working on your GED. Do you understand? I'm also going to drug test you. I'm not going to let you there's no smoking weed, none of this. Do you understand? If I find that you're using, I'm going to revoke your bond. I'm going to keep you. Do you understand? All right.
One other issue, Judge, we would request, the complainant has made contact with the DA's office and let her thoughts be known on the case in a RIP call. And so we request that the no contact be just brought down to no threatening, harassing.
Who is it?
It's a girlfriend situation, Judge. And I spoke to DV about it. He reviewed it and said he was going to leave notes, that they had no opposition to that.
Well, yeah, or even something else.
And yes, that is correct. The RIP does say no contact, so no threatening, harassing would be fine.
Okay. I will amend your bond condition, Mr. Ridley, to have no harassing contact with the complaining witness in this case. You're not to be in possession of any weapons. Do you understand? You need to start working on your education. Life doesn't get easier. Do you understand? That's my main concern. You graduate, you get your GED, we're all going to be jumping up and down because that's what you need. Without a high school diploma, you will literally make pennies when everybody else is making dollars. Do you understand? I'm bringing you back in 2 weeks. If you've done nothing, it's not going to go well. Do you understand?
Yes, sir.
Okay, see you in 2 weeks. All right. Good morning, Ms. Arlene. Sir, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. When due to probable cause, you have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 16, 2025 at 12:04 a.m., the officer observed a vehicle traveling the wrong way at Belfort Avenue in Harris County, Texas. A traffic stop was initiated, and the defendant, the driver, did not initially roll down his windows. After multiple commands by the officers, the defendant finally rolled down his windows, and the officer observed the defendant to make further movements as if to conceal something.
The defendant did not produce his driver's license, and the officer observed a strong odor of marijuana from the vehicle and his person. The officer observed the defendant to have a loaded firearm in his waistband, and the defendant stated he smoked earlier and was not the registered owner of the vehicle. The officer located in plain view, sticking out of the defendant's right pocket, a small package with training and experience is used to conceal marijuana. PC search was conducted, and the officer found 3.31 grams of marijuana under the driver's seat, and the defendant admitted the marijuana was his.
So Arlene, I'm going to find that there's probable cause to go forward with your case. If you run his license, see if he has
Not eligible, Your Honor.
Okay, you are not allowed to drive. I am making that a condition of your bond. I don't care what's going on in your life. If you don't have a license and liability insurance, you are not allowed to drive. Do you understand? You will be signing a promise with me. Like I said, I don't care if there's a burning building and you have to save 50 people. If you don't have a license and insurance, do not drive. I'm going to have you come up here, swear to us that you're not going to drive. Do you have the ability to hire a lawyer, Mr. Arlene? Okay, I'm going to have you fill out an application. I need to know everything about you, and I'll take a look to see whether you qualify. Don't pick up any new cases. Don't become a danger to my public, and above all else, do not drive. Do you understand? Okay, come on. Sir, you're charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
One moment, Your Honor, it's loading. Okay. On January 15, 2025, the officer was conducting surveillance in the Green Points area, and the officer was in an unmarked vehicle in an apartment complex and observed 18-year-old defendant join up with two other males, co-defendants. He had already witnessed using a firearm. The three males walked around the apartment complex together, and the officer witnessed the defendant being given the firearm and wave it around. The two other males encouraged the defendant to shoot the gun, and the officer did not see the defendant fire the weapon, and the officer maintained visual until the officers were able to detain all three defendants at a nearby gas station. The gun was found in the co-defendant's waistband, and all three individuals were placed in custody.
Mr. Savage, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand? I'm also ordering you as a condition of your bond not to be in contact with any. Did anyone else get arrested in this case? Or is it just him? I'm ordering you not to consume alcohol or illegal drugs. I'm sending you for a test right now. You're to come back. If you fail the test, if you fail to come back, I'm going to issue a warrant for your arrest. Do you understand?
Your Honor, there's a co-defendant in court 4.
That's the
The cause number is 254-773-4.
I'm going to send it? Okay, so let's just do this for now. Go ahead, take a seat for me. We're going to transfer your case to the other court because that's where it belongs. Okay, please. And you are charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 16th, 2025 at 2:02 a.m., the officer was dispatched in an attempt to locate. The officer was advised the defendant's sister was concerned for her well-being after not hearing from her. The defendant's sister stated her last known location was the Den, a bar, where she got a flat tire. While searching the area, the officer located the defendant's vehicle at the entrance of the University of Houston, and a witness was flagged down to assist changing the defendant's flat tire. The witness stated he observed the defendant as the sole occupant of the driver's seat of the vehicle, and the surveillance video showed the defendant's vehicle in motion at the time the witness came into contact with the defendant. The defendant was identified with Texas driver's license, and the officer made contact and observed a strong odor of an alcoholic beverage, red, glossy, bloodshot eyes, and slurred speech. The defendant admitted drinking a wine cooler earlier in the day, and standard field sobriety tests were conducted. The officer observed the defendant to be unsteady on her feet as she walked to the sidewalk, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 1 out of 4. The DIC was red, and the defendant consented to breath. The results were 0.185 and 0.181.
And you're telling me there's video of her driving?
Yes, Judge.
Ms. Levy, I'm going to find that there's probable cause to go forward with the case. Have you run your license and any prior DWIs?
Driver's license is eligible and no priors, Your Honor.
Okay. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If you consume alcohol or illegal drugs, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand, man? Would you like to apply for a court-appointed lawyer? Okay, I'll give you an application. I'll take a look at your numbers, and if you qualify, we'll provide you a lawyer today. Okay, just everything's fine. Don't worry. Just be safe. Okay, just don't. Okay, I don't want to talk about the case. Let's have you fill out the application, then I'll have you talk to a lawyer today. Okay, man? Please.
Right this way.
Sir, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 15th, 2025, the officer was dispatched to Texas Southern regarding a male on campus possibly carrying a firearm. The caller provided the name and dispatch ran through arms and located a recent picture and a trespass notice. The officer observed the defendant walk into the library, immediately walked out accompanied by a second black male, and the officer attempted to detain the defendant, and the defendant ran northbound, ran through an apartment complex. The officer drove through the complex and set up a perimeter and observed the defendant run out of the complex. The officer exited a marked patrol vehicle in full uniform, drew a duty weapon, and ordered the defendant to the ground. The defendant ignored the commands and continued running and was assisted to the ground by the officer. The defendant stated he ran due to being scared. The defendant evaded approximately 0.4 miles.
What was he doing wrong?
So there was a report of a possible firearm on campus, and the caller provided the name, and he was attempting to investigate that, and he was just trying to detain him to
They
investigate.
gave the description of him.
They just gave the name, and then they
A name
ran
of-
that through arms, and they found a picture of that person.
So the caller gave the name of Mr. Newman.
Yes, Judge. Gave Mr. Newman's name. The officer ran that name and found a picture, and then observed him leaving the library and attempted to detain him.
Yes.
And then he ran.
There was also a current trespass notice for the defendant as well.
Yes, Judge.
From TSU.
From the arms or TSU.
Yes, Judge. They found for TSU through arms.
Mr. Newman, I'm going to find that there's probable cause to go forward with the case. Let's do this. I'm going to appoint you a lawyer today because there's several things that we need to look at. So do you mind reaching out to the MAC for Mr. Newman? Mr. Newman, assuming we go forward with the case, you're not to be in possession of any weapons. Do you understand? I'm making that a condition of your bond. If I find that you have any weapons, I'm going to revoke your bond. I'm going to put you in jail. Just all I want is my community to be safe. I'm not asking for much. You understand? Okay. I'm going to have you sign a reset of Victoria, then we'll have you take a seat in the jury box, sir. Okay? So you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. You need to understand, sir, that this charge will go on your record. It's going to be there for the rest of your life. When you plead guilty, you give up the right to appeal, meaning that you can never change this. Do you understand?
Yes, yes.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. Do you understand these rights that you're giving up?
Yes.
You also need to understand that there are no more proverbial slaps on the wrist. From now on, you are facing a minimum of 30 days in jail for any new cases that you pick up in here. And if you're not in this country with permission, you do anything short of more than 6 hours, you will get an ICE detainer. So if I were you, I would never, even if you've had a sip of alcohol, get into a car and drive. Do you understand?
Yes, I
How do you
understand.
plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will sentence you to 3 days in jail, give you credit for the 2. I'm going to suspend your ability to drive for 90 days. Do not drive, otherwise you're going to be right back over here, sir. What does your client do for a living, sir? What does your client do for a living?
He does the carpentry work there, labor work, the framing, that kind of thing. Home framing.
I'm asking this because there is a DPS surcharge that they usually tack on for around $3,000. I will waive this fee for you now, but I'm telling you on a DWI second, it's around a $6,000 surcharge on a DWI second. So get a clue. Do you understand?
Yeah.
You're allowed to make a mistake, but when you continue to make mistakes with you endanger other people's lives, there are serious consequences. Good luck, sir. All right, win. All right,
Well, then, because there's a portable device, Judge, and you've been.
we'll take it off.
Thank you.
Okay, all right, please declare. Yeah. It looks like you are charged with 2 cases. You are charged with criminal trespass. You're also charged with criminal mischief. On both of those, you're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 48 days in jail with credit for the 16 that you've done on the criminal trespass. They're dismissing the other case?
Yes, Your Honor. Time served on the criminal trespass and dismissing criminal.
Is this how you understand it, sir?
Yes.
You need to understand also that this charge will go on your record. You're now facing a minimum of 30 days in jail for any new cases that you pick up. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. Like I said, you give up the right to appeal. So once you plead guilty, it stays on your record. Is this what you want to do?
So,
How do you plead? How do you plead to the offense, sir? Guilty.
I plead.
All right. I'm going to find you guilty. I'll follow the agreement. Good luck to you, sir.
What about the enhancement?
Abandoned.
Yeah.
Or wait a second. Is it listed as?
It's listed as.
Okay, hold on. Hold on.
Yes.
He's got to. Is it true or come on, Michelle Z? Is it true or untrue that you had a prior terroristic threat, sir?
I'm on my medication. So I missed my medication. I have trouble getting my medication. I was just.
Did you have a prior terroristic threat in the past? It looks like from August of this past year with us.
I don't remember any terroristic threat towards you. You guys or
No, just in general.
You had a case in this court that you took 57 days time on, and that was August 20th of 2024. Do you remember taking that plea?
I believe I was in court before, but
That's all we need to know. That's it. Okay. All right. Thank you. I don't know if have we found probable cause on this first case? Or I mean, on the new case? Let me express my extreme disappointment, Mr. Guevara Ortiz. You now stand charged with yet another DWI. On this one, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. On January 19th, 2025 at 11:43 p.m., the officer was dispatched due to a concerned citizen following a possible intoxicated driver. The call was near Northborough in Houston County, Harris County, Texas. The officer arrived at a public place and observed the defendant, the driver, and sole occupant of the vehicle. And the witness stated the defendant was observed to have severe damage to the front passenger side, and he struggled to stay in his lane several times. The witness had eyes on the defendant until the officer arrived, and the officer made contact with the defendant, who advised that he had 3 Coronas and was coming from a gas station where he purchased the beers while driving home.
So drinking while?
No, Your Honor, there's no indication of that. He just purchased while driving home. And the officer observed glossy eyes, delayed responses, and a strong odor of an alcoholic beverage. The officer conducted standard field sobriety tests, HGN 6 out of 6. The defendant refused the walk and turn and one leg stand due to the cold temperatures. The defendant was read the DIC and consented to breath. The results were 0.189 and 0.177.
Mr. Guevara Ortiz, I'm going to find that there's enough probable cause to go forward with your case, and I am now going to revoke your bond on your first case, and I'm going to set it at $10,001. You now also have an immigration detainer, so you will be stuck in there, I guess, until I need to know, counsel, if you guys are planning on trying to get him an immigration bond or not.
Your Honor, we don't represent him on the immigration case. That's my understanding from Mr. Breston that there's an effort to address that.
Okay. You're signing on for Mr. Breston now, right?
Yeah, I work for him. Yes, sir.
Got it. All right. Mr. Guevara Ortiz, I'm now ordering you to have an ankle monitor on your ankle, and I'm giving you a curfew of 7 p.m. to 7 a.m. I'm going to put a scram ankle monitor on you so I know that you're not consuming alcohol. On your other ankle, you will get a GPS monitor. I don't know if you're getting out of custody, but if you do get out of custody, these will be your bond conditions. You will have on one ankle, like I said, a scram monitor so I know that you're not consuming alcohol. On your other, you will get a GPS monitor so I know that you're abiding by curfew. Do you understand?
Yes.
Okay, so I guess we'll set you out for 30 days. Just keep us in the loop. If you do, if you're able to get an immigration bond, you must be here the next business day. If you fail to do so, I'm going to revoke both of your bonds and set them extremely high. Do you understand?
Yes.
Okay, all right.
Thank you, Your Honor.
Thank you, sir. Okay, so tell me what's going on.
Dave's asking for extension.
So this one for Sims, we're asking for an extension from Mississippi for a probation violation for malicious mischief. Obviously, due to Winter Storm Enzo, they're requesting extension because the airports were literally closed.
Get ready. We're going to get so many of these, you know?
Oh.
Let's get ready.
Yeah, they're coming.
And so this one, they're requesting out to the 27th. Or sorry, the 28th. They'll pick up on the 27th. But because even with when they were originally supposed to come on the 21st, it wrapped around the weekend. That's why we're entering the pre-signed waiver. Ricardo is opposed, which is why I'm entering it.
Okay, I mean, I have to, you know, circumstances beyond, I mean, act of God, right? As they say.
Of course, I gotta be opposed. I gotta fight for my client. His expectation was to get out at a certain day, through no fault of his own. He's gotta be here an extra 7 days, looks like. He doesn't control the weather. Nobody does.
Is it 7?
It's well, because the original pickup date was the 21st. Well, so yes, the 21st, and then the court reset date would be the 28th. They're looking to pick them up on the 27th.
Just get it a little bit less than a week. Understand that there's an act of God, right? That just completely close everything. You get just one kernel of snow, the entire city shuts down. So I'm going to grant them an extension. You're not going to get another one.
I have to ask Judge.
So understand, Mr. Kim, that I don't.
They had like 13 days before the snow. That's what I'm saying. Why didn't they come in?
Well, I can't answer that. I mean, that's something.
Oh, yeah.
Judge, I would ask, would you consider giving him a bond so he could go turn himself in and not have to wait 7 days? That's what we said.
For the pre-signed
There's
waiver.
a pre-signed waiver. I can't give
He's
them
not
a
allowed.
Understood.
Yeah, I mean, you know, you got to understand when you get on probation or when you get on parole in another state, you sign conditions. One of those conditions is that if you ever take off and you become a fugitive, you waive extradition. It's a pre-signed waiver. You have already waived by virtue of signing. You need to read every single thing that when you sign it, all the little print, because even if I wanted to give you a bond, I can't because you have already waived by signing that document.
If for some reason they don't make it by this deadline, will he be getting out?
That's a great question. Mr. Kim?
Actually, with the full, I got to look at the original waiver date. So it's 5th. So statutorily, they have until February 4th, 2025. So strictly speaking, for the pre-signed waiver, he's not allowed to, but this is one where they've already confirmed they're coming on the 27th. So I think it will be a distinction without a difference because they've already scheduled for him to come on the 27th, unless we get another once in a lifetime storm.
So we're gonna give him until the 4th is what I'm hearing?
Well,
No.
the recent's gonna be 28th.
28th.
That's not
They
one.
already indicated they're coming on the 27th.
I mean, act of God.
I don't see anything happening between now and then. Otherwise, the news would be just going nuts, you know?
Understood. All right,
Yeah.
well.
Here's where the pattern becomes impossible to ignore. The judge isn't reacting to one bad night anymore. He's responding to repeated choices, ignored warnings, and a history that keeps growing. Every condition, the ankle monitors, the scram devices, the curfews, isn't about punishment. It's about prediction. The court is saying, based on everything we've seen, here's what we think will happen next. And the scariest part? They're usually right. By the end of this docket, one theme is crystal clear. The courtroom isn't just reacting. It's running out of time.
I mean, should something happen, we'll cross that bridge when we get there.
We're back up here.
They said that they're going to come get you absolutely on the 27th. I don't know what time, but on that
I'll
day.
confirm with them that we approached and then submit the order and triple check today that that is still the confirmed date, because obviously we've had ones in the past where we confirmed too late and they had to move it. So I'm going to triple check today.
And he'll let you know.
I'll talk to them.
Okay.
Fine.
Thank you, Judge.
We'll talk some more with you.
This
Sir,
is where
you're-
the pattern becomes impossible to ignore. The judge isn't reacting to one bad night anymore. He's responding to repeated choices, ignored warnings, and a history that keeps growing. At this stage, every condition isn't about punishment. It's about control and prevention. The court's message is simple. If behavior doesn't change, freedom.
Sir, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. Do you understand?
Yes.
If you get pulled over, first thing an officer does is they look up your criminal history. If they see prior DWIs and they come up to you and say, smell alcohol, it's probably not going to go well. So from now forth, I would never, even if you had a sip of alcohol, get into a car. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never take this off. Do you understand? This is what you want to do.
Yes, sir. Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I will find you guilty. I want to send you to the agreement. Let me make one more thing clear, Mr. Espinoza. There is a $3,000 surcharge on this type of case. You pick up a DWI second, it's a $6,000 surcharge on your case that you can probably end up paying. I will waive it now, but understand, if you continue to put other people's lives in danger, it's not going to go well for you. Good luck, sir. Thank you.
Can we approach on something? I'd like you to hear probable cause and something.
Absolutely.
You have it pulled up?
Oh, yes, sir.
Okay.
So it's for Klaba. Okay. On January 15th at approximately 6 p.m., officers initiated a reverse prostitution investigation. Undercover officers saw defendant parked near where she was standing. Defendant rolled down his driver's side window. Officers approached the defendant and had a conversation sexual in nature. Defendant agreed to engage in sexual intercourse with the officer in exchange for $100. Defendant and officer arranged to meet at a motel. Defendant started driving in the direction of the motel. Defendant was then stopped and identified by marked units. During this, officers located a loaded firearm behind the front passenger seat.
During the search incident, sorry.
So it would have been my argument is that the possession of the gun was not while he was engaged in this alleged criminal activity.
And we would understand where he's coming from, Your Honor. However, he did have the loaded firearm behind the front passenger seat, and this was a search incident to arrest. So that's where we would be at.
We have the unusual circumstance here of my client is an aircraft mechanic. He works over at IAH. As a result of the gun case, not the solicitation case, the gun case, he lost his job. He can get it back because he's a member of the union. But the gun case is the only problem because he was charged with a gun. He lost his job. Now, I assume we're going to be able to work out the solicitation case.
I mean, I'm sure would probably work out in conjunction as well, you know? I mean, it's,
So, but in the meantime, he can't work. So.
Let me read the statute. Hold on.
That one will have to finish ours. Oh, what if he's one of the seats?
I tried to replace my plumbing, but I forgot to shut off the water. All you gotta do is glue stuff.
So I'm looking at 46.02. Unlawful carrying of a weapon. A person commits an offense if the person, one, intentionally, knowingly, or recklessly carries on or about his or her person a handgun at the time of the offense. So is this at the time of the offense? Right? I guess there lies the question.
He was proceeding to the motel where the incident that they agreed to would occur. So during the process.
So because, I mean, the offense is committed when? When the actually agreement took place.
Requires the way the charge reads, it requires the offense is complete at the time that an agreement is
reached.
made. So
The agreement is made at the time, allegedly, when they're stopped. They had the wherewithal, if they wanted to, arrest him at that time, where subject to arrest at that time, they could have made the charge, so to speak, right? But they decided to wait.
Well, Your Honor, if I may, the statute reads they had honor about his person while committing criminal activity, and the firearm was in the vehicle while the offer was being made. It was just on the way to the hotel or the motel is when they stopped him and search incident to arrest for that solicitation. That's when they found the firearm. But the firearm was on or about the defendant's person while he was engaged in the offer for the solicitation.
And also, if I may, Judge, I would also say it would make sense for safety procedures for them to make the arrest while he was on the way to the motel so that they could have followed him and it wasn't just that undercover officer there at the scene and making the arrest.
No, I don't know, because they could have arrested him at the time, right on the spot. I don't know why they would try to bolster the case, I guess, by saying that there's more evidence of guilt by actually going to the motel. I mean, theoretically, they could have arrested at the time that the agreement is made, right? It's a contract.
Judge, I think we would just stick to the way the statute is worded is while engaged and the firearm was there. And they could have arrested him earlier, but as Mackenzie knows, they do that routinely for safety purposes as well as perhaps as you mentioned, they could have done it for further evidence as well, further investigation.
Prostitution cases I've seen is they arrest right on the spot, right then and there. They don't wait. I mean, the offense occurs right then and there.
And the offense did occur, and while the defendant was in the vehicle, that's when the offense occurred. He was in the vehicle when they made that agreement, and the firearm was in the vehicle. They found it right after they followed him to the motel. It was in the same transaction.
the offense was complete.
I agree with you. I'll find no problem with calls. Okay. So you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 28 days in jail with credit for the 28 days that you've already done. Is this how you understand it?
Yes, sir.
Excuse me. This charge will go on your record. It's going to be there for the rest of your life. You need to understand that from now on, you're facing a minimum of 90 days in jail for cases like this that you pick up.
Yes.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this.
Yes, sir.
What you want to do?
Yes, sir.
How do you plead to your offense? How do you? I'm going to find you guilty. I will follow it. Good luck to you, sir. Thank you, Josh.
Officer Sims?
You were charged with assault, bodily injury.
شما در واقع به حمله مسلحانه به کسی حمله کردی اونجوری متهم شدی که به کسی حمله کردی.
Do you understand how she's okay? You are facing up to a year in jail and or a $4,000 fine.
میگه 1 سال بعد زندان بری و $4,000 بعد جریمه پرداخت کنی.
We are going to do probable cause.
در واقع اینجا میخوان برای شما یه excuse me sir, I don't know exactly what does probable cause mean. Sorry about that.
We're going to determine whether there's enough evidence to go forward or not.
میگه در واقع میخوان شواهد رو بررسی بکنن که ببینن بعد چجوری در مورد مسئله شما تصمیم گیری بکنن.
You have the right to remain silent. Anything you say can or will be used against you.
میگه حق اینو داری که در واقع ساکت بمونی، هیچی نگی و هر چیزی که بگی میتونه علیه شما استفاده بشه.
If you cannot afford a lawyer will be appointed to represent you.
میگه اگه که توانایی در واقع هزینه پرداخت وکیل رو نداری، دادگاه برای شما یه وکیل انتخاب میکنه. یعنی میتونی ساکت بمونی و بگی من وکیل میخوام. وکیلت میتونه از تو دفاع بکنه.
I'm now going to have Alex, our local prosecutor, read what happened. So, go ahead.
میگه الان این در واقع اون کاراگاه مخصوصشون که کاراگاه مخصوص این کار هست برای شما میخونه که چه اتفاقی افتاده.
Okay, go slow.
Yes, Judge. On January 15th, 2025,
میگه در 15 ژانویه 2025
The officer is dispatched to a possible assault.
فهمیدن که شما به کسی حمله کردید.
The officer observed one student being assaulted by two other students.
میگه اون در واقع اون آفیسر اون مأمور دید که یکی از دانش آموزان به وسیله دو دانش آموز دیگه مورد حمله و ضرب و شتم قرار داده شد.
The officer stepped in and grabbed the defendant and escorted him to the police office.
آفیسر اون مأمور پلیس در واقع وارد مداخله شد و اون کسی که صدمه دیده بود رو برد به پلیس، به دفتر پلیس.
Surveillance video showed the complainant speaking with the defendant in the cafeteria with other students.
میگه که اون ویدیویی رو که در واقع داشتن بازرسی می‌کردن که ببینن چه اتفاقی افتاد، توی این ویدیو دیدن که اون دانش آموز تو کافتریا داشت با اون دو دانش آموز دیگه صحبت می‌کرد.
Students separated the defendant and the complainant after the defendant charged at the complainant.
میگه بقیه دانش آموزا اون کسی که مورد ضرب و جرح قرار داده شده بود و اون کسی که داشت ضرب و جرح می‌کرد رو در واقع جدا کردن از هم دیگه.
The defendant was being held back when a 15-year-old started punching the complainant.
میگه که اون دیفندنت اون کسی که مورد حمله قرار داده شده بود خودش رو کشید عقب وقتی که دید اون یکی دانش آموز در واقع با لگد بهش زد. Yes.
Ma'am, please don't talk. If you want to talk, you can go out.
Yes, Judge.
Did you just say the defendant was being held back?
Yes, and as I keep going, he breaks loose. So the defendant broke loose from the other students and joined the 15-year-old in the fight.
میگه اون کسی که مورد حمله و ضرب و شتم قرار داده شد خودش رو به عقب پرتاب کرد. Sorry, can you please repeat the second part of the sentence?
Yes, so the defendant joined the 15-year-old in the fight.
میگه اون کسی که مورد ضرب و شتم قرار داده شد در واقع به اون یکی دانش آموزی که 15 سال بود به اون ملحق شد.
The defendant punched the complainant multiple times.
میگه اون کسی که در واقع مورد ضرب و جرح قرار داده شد چند بار ضربه زد به اون یکی دانش آموز.
The complainant stated he felt pain after getting thrown on the ground.
Sorry, can you please repeat it one more time?
Yes, no problem. The complainant stated he felt pain from getting thrown on the ground.
اون کسی که در واقع مورد حمله قرار داده شد که در واقع شاکی بود میگه بدنش درد گرفت بعد از اینکه مورد اون ضرب و جرح و حمله قرار داده شد.
Who is the complaining witness? And where was it?
So the complaining witness is another student and it took place at a school.
بازی میپرسه که اون شاهدی که در واقع داشته میدیده جریانات رو اون کی بوده و ایشون اون پروسیکیوتور دارن میگن که ایشون یه دانش آموز دیگه بود اونجا که در واقع صحنه رو دید که چه خبر شده.
Which school? So I'm trying to find, Your Honor.
Wisdom High School, Judge.
Hey. Have you reached out to the complaining witness?
Yes, Judge, I've attempted to reach out to the complaining witness. I have not heard back from him.
Okay, so I'm going to find probable cause exists to go forward with your case.
قاضی میگن که من در واقع میخوام حالا اون شواهد رو پیدا بکنم که ببینم که چجوری که این مسئله کیس شما رو جلو ببرم.
As a condition of your bond, I am ordering you not to have contact with the complaining witness in this case.
میگه اگه بخوام در واقع برای شما یه ضمانت قرار بدم ازت قاضی خواهش میکنه که با این شاهدها با این شهودی که وجود دارن نباید در تماس باشی.
I'm also ordering you not to be in possession of any weapons.
و همچنین نباید هیچ نوع سلاحی با خودت داشته باشی. نباید هیچ سلاحی حمل بکنی.
If you violate any of these conditions, I will revoke your bond and put you in jail.
قاضی میگن که اگه از این چیزایی که من گفتم سرپیچی بکنی میری زندان.
Do you understand?
متوجه شدی؟
Would you like a court-appointed lawyer today?
دوست داری که در واقع دادگاه برای شما یه وکیل اختصاص بده، یه وکیل داشته باشی از طرف دادگاه؟ Yes, he does.
I will provide you one. My only other issue is whether to bar you from going back to the school or not.
قاضی میگن که برات یه لویر یک وکیل برات انتخاب میکنن، فقط مسئله مورد نظرشون اینه که نمیدونن بعد اجازه بدن که تو برگردی به مدرسه یا نه.
I will have you speak to the lawyer and we will determine how to go forward.
قاضی میگن من با یک وکیل صحبت میکنم و از اونجا در واقع ببینیم که چجوری بعد مسئله رو پیش ببریم.
Do you understand?
متوجه شدی؟
بله. Okay, we will have you fill out an application. I will have you sign a receipt with Victoria, and then we'll go. I'll have you give it back to me, and I'll look and provide your lawyer today.
میگن یک چیز به نام اپلیکیشن به تو میدن، اونو بعد پر بکنی، به یه خانومی هم بهت کمک میکنه، بعد اونو تحویل میدی و برای تو وکیل انتخاب میکنن.
Thank you so much for the help. I appreciate
Of course. Of course.
Okay.
Thank you. You're welcome.
Yes, ma'am. You're free to go.
Thank you. Bye.
Sir, you're charged with terroristic threat. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On September 11th, 2024, in Harris County, Texas, an officer met with the complainant who advised that in the morning he received multiple phone calls from an unknown number beginning at 4:30 a.m., lasting through 4:50 a.m., in which the defendant called a total of 5 times. The complainant stated he did not answer the phone from previous knowledge that it was the defendant calling him to confront him. The complainant stated he left to work, and when he returned at approximately 4 p.m., he noticed multiple phone calls from an app-generated phone number that called him a total of 18 times. The complainant stated that on the 18th call, he answered the phone and let the defendant talk. The complainant was able to get a second cell phone and record the defendant, stating, "I know where you stay at. You don't know where I am." The complainant stated he had sent a text message to the phone number that the defendant kept calling from, and said that he did not wish to have any contact with him and to leave the complainant alone and stop calling. The complainant stated that during the conversation over the phone with the defendant, before he was able to record the phone call, the defendant stated he was going to shoot the complainant in the legs so he could not work as an electrician. The complainant stated that the defendant is the complainant's current girlfriend's ex-boyfriend. The defendant is the complainant's current girlfriend's ex-boyfriend. The complainant told the officer that he believes the defendant is capable of carrying out his threat and the complainant is in fear for his life.
All right, Mr. Barrera, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have contact with this person. Do you understand? I'm also ordering you not to be in possession of any weapons. If I find that you violate any of these conditions, if you are a danger to my community, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand?
And Judge, given my conversation with the complainant that I had yesterday, the state would request a GPS monitor because he has continually gone to the residence since this incident and has made threatening comments towards the mother-in-law as well. And recently, as of a couple of days ago, I guess he left his wheelchair outside the home in order to make some sort of threat that he's been going near the residence.
So the threats are still continuing?
Yes.
Sir, I'm now putting a monitor on your ankle so I know that you're not going over there. You're not to go within 1,000 feet of where they live or where they work. Do you understand? Hold on. I don't want you to say anything. I will give you a lawyer today. You can talk to the lawyer, but understand my only concern is community safety. That's all I care about in this life. You know, we take things step by step. Let me do this. I'm going to give you a lawyer. I'll let you talk to the lawyer. I got a bunch of DAs here. Whatever you say, they're going to use it against you. Let me give you a lawyer. We'll go from there. But don't go where they live. Don't go where they work. Don't accidentally bump into them. Do you understand? So it looks like you have a fugitive case. Oh, you picked up 3 cases. You picked up a fraudulent use of ID, less than 5 items. You picked up a theft case, and you have an out-of-state fugitive case.
One of them has been dismissed, Judge. The fraudulent use of items has been dismissed. So technically, he's only got the theft pending and the fugitive case pending.
Mr. Kim, enlighten us.
Your Honor, this defendant is wanted out of Broward County, Florida for felony theft. The state would be opposed to a bond. There are 47 cycles of criminal history in the past 5 years alone, and these are just convictions.
47 pages of criminal history in 5 years?
47 cycles, Your Honor. For pages, it is 46 pages of criminal history, including, well, the California one's old, so I'm not going to count that one, but just in the last 5 years alone, and these are just...
They were not 47 in the last 5 years.
Hey, don't talk. I mean, we're just trying to, the thing is, Mr. Jones, is I have a very limited amount of time to try to get to know you. Everyone that comes in front of me tells me it's gumdrops and rainbows and little bunnies jumping in the woods. But the way I really get to know you is the paper, because that tells me who you are, right? If you're a dangerous person, if you're a person that I'm going to let go and you're going to continue with the criminality, I have enough trouble sleeping as it is. I don't want more blood on my hands. I don't want something else that's going to keep me up at night. So that's why. Well, but this is how we get to know you. And he's telling me you got 46 pages of criminal history.
Your Honor, in the past 2 years, he's had 3 failure to appears of multiple cases. He's had 2 habitation trespass convictions, a DWI, prostitution, battery, criminal damage, failure to appear, possession of drugs, felony, obviously, resisting. But in the 21 some odd cycle, or in 21 some odd years, it's the 47 cycles of different offenses, and I just stopped scrolling after 2020.
How many failure to appears do we have?
3, Your Honor. And this one itself is a no-show, or according to the transmission.
Hey, Young, could I say something?
Sure.
Okay, with the one you come out with the failure to appear, I feel that was nonsense because of the simple fact that I flew from Fort Lauderdale up here after they said I had a warrant, and I went to court a couple of days before that. And is that documented, sir? You can see that.
Judge, I will say this, he did explain that
How
to
old are you,
me.
Mr. Jones?
I'm 40 years old, sir.
You're 40.
Yes, sir.
How many cases has he picked up in total?
That he's been charged with. If you give me 10 minutes, I can count them, but it's not low. I mean, I can start from 2004.
So theoretically, for every year you've been born, you've had a case.
I have a
You're
question.
40 years old, and you have around 46 pages of criminal history. So literally for every year you've been born, you've like picked up a case. And not only that, you've got multiple failures to
Sometimes you don't think the jurisdiction will fail me?
Huh?
You don't think the jurisdiction will fail me?
But the problem is, at some point, your actions become your own. You now have with us, you've picked up a theft case here in Harris County. You've got an open case in another jurisdiction. You've got pages upon pages. So at what point is it on you?
When you pay your debt to society, why do they keep using it against you? I pay my debt to society for those.
Because it continues.
For those fires, okay.
Continues to happen. At some point, DAs are like, jail just doesn't work anymore. So that's when we got to go to prison, because this dude.
But prison don't help guys. That don't make them better. That makes them worse. Instead of tormenting them and sending them and feeding them to the wolves, y'all should sit down with that person to find out what's going on to help that person. Instead of prison not helping nobody, prison is not.
I can't tell you how many stories I have read of people who get degrees, college degrees, even become a lawyer while they're in prison. So if you want it to help, then it will. But you got to want it. If you
One bad as me, Your Honor.
If you
But
have,
the sad thing about it is, and in the state of Florida with me, and that's why I left. Something happened, and I have a conflict of interest against the police. So now they're jugging at me every chance that they get. But it's crazy. He's saying I have a warrant, and I flew from there after that warrant was pro se. Pro se that they said I have. I flew from Fort Lauderdale all the way to Houston, flew back down there, and flew back. And they said I have a warrant, and I flew and went to court for another charge down there.
I don't get it.
And I went inside.
I don't know how that happened, but it's not supposed to.
So who's the system failing? If I have a warrant, you mean to tell me they're gonna let me in their courtroom, attend to my judge, see my judge, everything, and let me go, and let me get back on the plane to fly back here? Mind you, I flew from here and flew back down there. They let me do all of this with a warrant?
I can't explain that. I can't.
So that's the system failing somewhere, somehow. That's not me.
Let me talk to the judge real fast.
But Mr. Jones, if you have this woe is me attitude, it's never going to change. It's never going to change.
You're not helping. It's not helping. Y'all not helping society. Y'all always blaming me and this and that and the other. Prime example, he said, oh, he got prices from here. And he went to call this stuff off. That he said, well, only stopping from 2022, and he going past 2022. And I'm like, yo, but that's what the prosecutor do. He just doing his job.
Right, that's what he's doing.
Judge, if I may, sure. Points. First, if he's finished up the cases that he has had in his history, he's had a history. Okay, he's had a history. If he's paid his debt to society, like he says, if he's completed what he needs to do for those cases, that really shouldn't be relevant here. I would argue that in front of you, this is his first time being in front of you, right? And it looks bad that he has a criminal history. Yes, I get that. But if we were to just focus on whether or not he knew about this case, he's telling me he got on a flight, came over here, and it's a great question. If that happened, he would have had a warrant pending and he would have been arrested. So
When was the warrant issued, do you know?
March 3rd, 2025, but because it's a domestic flight, and obviously I don't work for TSA, I don't work for Department of Homeland Security.
Just got issued.
just March 3rd, 2025, Judge.
Your warrant was just issued in March of this year. So
And I flew,
30 days ago, it got issued.
and I flew March 10th back up here.
So Judge, if that's the case, it hasn't been like he's been missing his responsibilities with
And
this
I went to
case.
court. And
It's
you
less than a month.
And you can
that
also
he's had
see
this
that I went to court. I went to court before March 3rd.
That's why the failure to appear, which is
How? I went to court. I went to court before then.
Judge, the warrant has
I was
been
in the
issued
courtroom.
we're at April 1st, less than a month. And so it's not like he's been running. If the warrant's just been issued on March 3rd, I would ask that we afford this man an opportunity to make this right. He hasn't messed up in your eyes. Yeah, he's messed up in the past, but as far as the fugitive case is concerned, I'm asking for an opportunity for him to go to the demanding jurisdiction. And then if he messes up, okay, well, I don't have much to say after that. But just throwing his history out there, it doesn't mean he doesn't deserve a chance.
I stand by the no bond. He has assaultive history as well, and it shows in the message that we received from Florida is that he has violent tendencies, obviously reflected by the assaultive history, along with and I don't have to go ad nauseum, but the significant criminal history that he has.
When were the FTAs? How long ago?
The most recent failure to appears, one moment, Judge. There's one from May 4th, 2023. There's one from December 7th, 2023. There's one from.
It's not on this case, though. Those are separate cases. We're not talking about on this case. Are we?
To be clear, it's not on this case, but.
Obviously not on this case. But the problem is that it keeps happening, and I can't continue to.
Sir, it's not keep happening, sir. Sir, this warrant that he said, sir, I went to court. I'm gonna be honest with you. I have another open case, and that open case is why I flew back down there. Went to court, finished court. They said I have a warrant. I go to the warrant district. They said I have no warrant. Leave the warrant district, get on the plane to fly back up here. And they said I had a warrant before I even flew on the plane back down there. So how could I fly?
Mr. Jones, even if I were to set you a bond.
Okay, no problem. Hey, send me back there, man. Can't about this shit, man.
Easy money. There you go.
So for the second one, we're going to be, well, actually it's going to be Ricardo's request, but.
Yeah, Judge, on the.
If you want me to take it off, I will.
Yeah, on the second one, let's take it off. I'm concerned about HIPAA stuff and.
Ask them to bring him back.
Yes, Judge.
You want to go through the list?
Yes, Judge. Oh, that's not, no, my person is,
Mr. Nelson has a warrant out of Florida. He did have a local case that was resolved this morning.
Just dismissed. Yeah, today.
Yeah, it was, actually, I think.
No, I got actually pled. Right. Okay.
He pled on that. He previously had signed a waiver 7 days ago, I think, but
March
he-
31st. March 31st.
March 31st.
Oh, yesterday.
Last Friday. But anyway, his value of time is probably exaggerated. He has a warrant for Florida. He's been picked up on this before in Tennessee, and they didn't extradite him from Tennessee. They released him after 3 days. He's back in jail here in Texas now, obviously, for the same charge out of Florida, and he is a cancer patient, and he's wanting you to grant him a PR bond so he can go back to Florida.
That's where I was heading.
Really?
Yeah, it was.
Oh, it just so happened that
No, sir.
and you got a failure to ID as well.
But that's, the failure to ID was, they pulled a gun on the guy they were looking for, and I was at the crosswalk. I wasn't there. They weren't stopping me. They stopped another guy. They were waiting for 3 days or whatever to get him. And then yes, sir.
It doesn't matter.
This is not our first time being here on this case, Amy,
he's previously had a fugitive case in Tennessee for this.
for this same charge.
Well, just a fugitive case in general. I can't say what.
So that was in Tennessee. Now he's wanted out of Florida.
No. He had this exact same proceeding in Tennessee.
Meaning he was a fugitive in Tennessee because of Florida.
Yes, he was incarcerated in Tennessee and had a hold on him from Florida. They chose not to extradite him at that particular time, and he was released 3 or 4 days there.
How long ago was that?
How long ago was that, sir?
5, 6 years ago.
And after 5 to 6 years ago, you still haven't taken care of the case.
That was during pre-COVID, and we were coming back from Michigan, and we were on our way down, and we stopped in Tennessee. I started working at the hotel, And they came in and they said, out of the clear blue, looks like you got a warrant. And I go, what? Okay, so they took me in, they ran everything, they held me for 3 days and they let me loose. They didn't, there was no new charges or nothing.
What's he wanted for?
It's domestic violence.
In Florida, he's wanted for a couple different warrants on bond revocation for domestic battery by strangulation, violation of pretrial for domestic battery, violation of pretrial for domestic battery by strangulation, failure to appear for domestic battery, strangulation, and grant that.
That was back in
And it's been open for
12 years.
And you still won't go back?
No, we were gonna go back. That was the whole thing. I was in
The
Florida.
only thing I'm waiting for you to say is that you were abducted by aliens that prevented you
I'm
from.
not gonna lie to you, sir, but we were going back. When COVID hit, actually, I was in Florida. That's where we went from Michigan to Tennessee, then Tennessee down to Florida during the pre-COVID. And we were in, I think Pensacola. And we were there for like 3 months and we were waiting for the COVID to stop, but it just didn't end. So I ended up talking to a gentleman that had plenty of work for me across the country to go to all of his hotel properties to fix them and find out why they were failing, why were they not making any money and what was going on. So that's what I've been doing.
Does Florida really want him? Are they gonna come get him? Or are we just playing games here? You know, because if they really want to get him, I'm gonna hold him. But if they're not gonna come get him, then I'm not gonna hold him. We have enough people in our jail as it is. So let's do this. The problem is, Mr. Nelson, you don't learn your lesson. You've repeatedly been arrested on this charge and they've told you to go back and you refuse to go back. So I can't, in good conscience, give you a bond when you refuse to comply with court orders.
I understand that.
Just don't want to do it. You want to do what you want to do. And then, hey, if I happen to get arrested, they're not going to come get me anyways. So
no, I don't say that at all.
You don't say it,
right?
But your actions say
I
something
understand.
different.
I understand that. I do.
When people tell me stuff, it goes in this year, it goes in what matters are actions.
I understand.
So
With regards to Florida, I'm happy to check up on that. He does also have other warrants from other states. He has a probation violation from Michigan and also intimidation.
They're not
scotching with states, man.
Oh, they already told the jail. They already made the call. They're not coming. They don't want nothing to do with me. That's already been.
They don't have a hold file right now, but he does have the other warrants.
And those are from 2009. And I served my time on all of it, but it's just.
So
I understand.
Let's roll it to tomorrow. Please reach out to Florida and see, do you really want him? If you do, here he is. If not, can we, really?
We'll be back tomorrow. Thank you so much, Your Honor.
All right, Mr. Nelson.
Hey, I love your show.
I don't have a show.
I watch on.
I like you
too.
True story.
We are approaching on Mr. Avalar.
Thank you. Okay.
And I believe defense, I wanted to ask about bond conditions.
Yes, Your Honor. So yesterday, I believe you gave him a $5,000 bond. He picked up an offense for violating bond conditions. Your Honor, it turns out that the facts are that he had stayed away, his, the woman who he was in this issue with, her house caught on fire, burned to the ground. She called him asking for assistance. He said, hey, I don't know. I don't think I can be talking to you. And then 2 days later, she got into a car accident where her vehicle was totaled. And she said, please, I have nowhere to go. Can you help? He said, look, I'll help you find some place to go and I'll drive you there. And that's it. In the midst of driving her there, he was pulled over for no registration.
Calls Murphy's Law is what it's called.
And she said, I've got bad juju.
You know?
The state confirmed all this.
Yes, Judge, so
Go ahead and bring him out. Avalar.
Judge, the prosecutor on the case did call the complainant. She pretty much gave nearly the exact same story of her apartment burned down. She was just trying to get a ride. They have not had contact up until this point. So we are not ready to offer a plea today because it is a new case.
Sure.
But we are okay with a PR bond at this point, just given the circumstances and the facts.
What do we do about conditions?
Conditions, we would still like to keep that no contact in place. It seems like they didn't have an issue up until this point with it. So we would just reinstate that no contact.
I will ask for a short reset, Your Honor, but from speaking with the CW, she communicated to me that the whole thing was a misunderstanding. She feels safe around him, and honestly, she'd like for them to be able to have contact. The way she communicated to me, the initial situation was they were arguing, a police officer was coming by, so she flagged him down so she could stay away from him. And then while talking to the officer, she showed him, like, look at this message, you say he's gonna do this to me. But that's in the course of how they normally communicate to each other. She didn't feel afraid, the officer just took it to that next
How
level.
about the assault we talking happening in the zone?
So, Judge, I believe the case for us right now is a terroristic threat. So
We're just looking at the terroristic threat charge.
Jail.
Sorry.
Sucks, right? It's supposed to suck. That's what happens when you don't do what you're supposed to do. You can't do stuff on your own and think that good things are going to happen. It's what I was telling your lawyer. It's called Murphy's Law. What can happen will happen. I get that you may be trying to help someone, but a court order is a court order. And when you don't follow them, bad things happen. And that's why I'm saying, maybe it's divine intervention that like you get pulled over right on the day that you're trying to do this. So really, now both of them are in agreement for you to get a PR bond because really it's not a capital case, but you have to understand the court orders are court orders and they're still there. If you want them taken off, if you want to do something different, you have a lawyer and you ask a lawyer to help you out, but you just can't do stuff on your own and expect good things to happen. Now, state is still asking for you not to have contact with this person and as of right now. So I'm going to give you a PR bond now because they're both in agreement. I'm telling you now, you do this again, you will not get another one. I promise you on everything that's holy. Do you understand? If you want something, ask. We can always address it. We can always fix it. Just don't do stuff on your own. That's when it goes sideways.
Sir.
Give me questions. Okay, so I'll grant you a PR bond. We need it on both cases, I think, right? So do you mind filing a new no contact order now? No weapons, no contact. Don't for the moment. Perhaps time will heal all wounds. Perhaps after some time, after she speaks to the complaining witness, things can change. Just don't do it again. All right?
Judge, I believe there is a order for emergency protection in your queue. It was filed the 30th, so it should be in there. Do you want me to file another one?
It's 255-1405. That's the initial terroristic threat.
Yes, there was a protection order signed on February 13th.
And then
You okay with that?
he's made bond.
Okay, done.
Nice, Jenny.
Made bond on the BPO already.
Oh, right. So we'll just leave, and I didn't do anything to the VPO. So we'll just give a PR bond on the terroristic threat.
Reinstate the PR bond.
Yeah, I'm okay with that.
And so just a reinstatement on the.
Whatever's easier. Yeah.
Okay.
Are we good? Okay. Thank you. So hold on, let me take, okay, we're good. All right. Jason Fisher, right? Okay. So Mr. Fisher, you're charged with two cases. You're charged with driving while intoxicated. Second offense, you're also charged with failure to stop and get information. You have worked out an agreement where they're offering you 180 days in jail with 72 days credit on the DWI second, and they're going to dismiss, I would assume, the FSGI.
And there's kind of felony that was keeping it in, keeping it in custody.
Got it. Is this what you want to do? You need to understand, Mr. Fisher, that from now on, if you pick up any more DWIs, you'll be looking at yet another felony. We're not asking for much, man. All we want our streets to be safe. Here, we have a second DWI and a crash. What's it going to take? Kill someone? Do you want to end up with a 50-year sentence? Next time you ever get into a car and you get pulled over, all officers do is they look at your record, and that's all they care about. So if they pull you over, they see that DWI, FSGI, DWI, possession, and they come to you and they smell alcohol or dope. What do you think they're going to do? You think they're going to be nice? Probably not. Don't get into a car if you've had anything to drink. You understand? Are you sure? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. This will go on your record. It's going to be there for the rest of your life. You can never take it off. Do you understand? How do you plead to the offense of driving while intoxicated second offense? I will find you guilty. I'm going to suspend your license for 2 years. Do not drive until you get a license. Do you understand? Yes. All right. Good luck. I don't know if you think that this is a joke, but you've been given a very, very generous program that if you complete successfully, they will dismiss this case. You have tested positive. Is it multiple occasions or just once? This is Mr.
I'm sorry.
Canales.
Oh, sorry.
That's okay. Victoria, you're counting.
That's my fault. Chair.
He's tested positive.
How many times?
3 times.
That is unacceptable. And if it were me, we'd be done. They see fit to put you into an intensive outpatient treatment. You have 2 weeks to enroll. And I'm going to tell you right now, you ever test positive again, I'm going to immediately set your case for trial. You get no more resets. Do you understand?
Yes.
I want you tested 2 times a week for the remainder. Okay? You will now be tested every Monday and every Thursday for the remainder of this program. And if you use again, and I don't care what it is, and I don't care what your excuse is, you will be set for trial.
Okay.
Do you understand?
Yeah.
Okay?
Yes.
All right.
Thank you, Judge.
Is it okay if we test in that region or would you like?
No, I'm okay, of course. I don't care where, as long as he's doing it 2 times a week.
Okay.
No, I got it.
Judge, we'll be bringing out Mr. Alexis Jones.
Mr. Surovov,
Yes, sir.
you are charged with evading arrest or detention and driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be pointed to you, sir.
Officers were dispatched to 300 Memorial City Way, Memorial City Mall, for a male detained on suspicion of driving while intoxicated. Defendant was observed by officers as well as several security officers driving erratically in the parking lot by failing to stop at a designated stop sign in that parking lot. The defendant was observed on security cameras stepping out of his gray BMW sedan, exposes genitalia, and urinate next to his rear driver's side tire. Officers made contact with the defendant and smelled a strong odor of alcohol, slurred speech, and observed 2 empty containers in the vehicle. Officers detained the defendant. Defendant was erratic.
Drinking while driving.
Containers in the car yard. Defendant was erratic once placed in the back of the patrol vehicle and continuously banged his head on the window. Defendant spit at a security officer, which made contact with that security officer's left cheek. Defendant denied drinking. Standard field sobriety tests were conducted. Following results: 4 of 6 HGN, 5 of 8 walking, 3 of 4 one-leg stand. As far as the evading goes, Your Honor, officers attempted to grasp the defendant in order to detain him while he was being detained. To try to put handcuffs on him. The defendant was able to slip out and evade it for approximately 100 feet before he was once again detained and placing the handcuffs in the back of the car.
I'm going to find that there's sufficient probable cause to go forward in both of your cases. I am now taking away your privilege to drive. You are not allowed to drive whatsoever for any reason, and I don't give a rat's behind what your excuse is. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I am now sending you for a drug and alcohol test. I want to know what, if anything, is in your body. If you fail to take the test, if you fail to come back, I will issue a warrant for your arrest. You were to come back, and then we will continue on your bond conditions. If you have a problem with drugs or alcohol, you better address it. Because if you don't, I'm going to do it for you. And I promise you're not going to like the way that I do it. Do you understand? As it stands now, you will get a scram device that I'm going to put on your ankle so I know that you're not consuming alcohol or anything else at any time. And I'm going to drug test you like crazy. At the first instance you use anything, I will make your bond so high, you'll have patches of hair falling out. Do you understand? Come up here, swear to us that you're not going to drive, and then we'll send you for a drug test, and then we'll have you come back.
I'm here on Alexander Sorovov.
Okay. Come up. Good to see you.
I know, good to see you.
Been a while, huh?
I know.
We sent him for a test.
Yes.
Yes, judges presented for morphine.
Morphine.
Judge, he broke his arm and he's on Tylenol with codeine and he got out of the hospital March 28th and they had also given him stuff there. And we do have a prescription. So I don't want you to be upset about that. You can be upset about other things, but not that.
How long? Because they don't give that very much now at all, if ever. Are they giving these kind of... So I'm going to test you like crazy to ensure that you're not using. I'd like a copy of the prescription. I want to know how many pills there are so that we know how long he's taking it, because if he's testing positive for weeks upon weeks, then it's unacceptable. If I find that you're using, if I find that you're using alcohol, if I find that you're a danger to my community, I only have one place for you. Do you understand? I will do everything in my power to protect my community at all costs. I don't care who you are. I don't care what color you are. Do you understand? So he gets tested weekly from now on so that we know how much he's using. You have a lawyer. It is your responsibility to stay in touch with her. She tells me she can't get a hold of you because you're playing games or you pick up a new case. You're not allowed to drive. Do you understand? If I find that you drive, that would be the absolute worst, and you're looking at a possible contempt charge. You understand? Okay?
Judge, if I could ask one thing, I wasn't here for bond conditions, and there's got an ankle monitor.
So, right. It was crammed, so he's not using alcohol. I put a GPS on him so he's not out in the middle of the night, because I don't want him out in the middle of the night as well.
Okay, so it was just, he works at a mall, and he sometimes closes at 9, so it's just 9 to 6. I was just saying, could we make it 10? Because if you close, okay. Okay, thank you. Okay, thank you, Judge.
Good luck. Ms. Burgos, you are charged with driving while intoxicated. You have worked out an agreement where they're offering you 45 days in jail with 15 days credit. You give up a lot of rights by entering into this agreement. You need to understand that after today, this charge will go on your record. It will be there for the rest of your life. If you ever get pulled over in a car and you smell like alcohol or dope, and an officer sees this, it's probably not going to go well for you. From now on, you are looking at a minimum of 30 days in jail for any new cases that you pick up. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, right to be arraigned, charge rights in open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, you can never change this. Knowing all this, do you still want to do this?
Yes,
How do you plead to the driving while intoxicated? Guilty or not guilty?
guilty.
I'm going to find you guilty. I will follow the agreement. I'm going to suspend your ability to drive or your ability to get a license for 90 days. Do not drive until you get a license. Good luck to you, man. Thank you.
This hearing highlights the court's strong focus on public safety over repeated excuses. Many defendants face charges related to DWI, probation violations, fugitive warrants, and failure to appear, showing a pattern of non-compliance with court orders. The judge consistently emphasized that prior criminal history affects present bond decisions. Court orders must be followed strictly. Addiction issues require immediate treatment. Repeated offenses reduce chances of leniency. While the court granted PR bonds and treatment options in some cases, it made clear that continued violations could lead to harsher penalties, including jail time and higher bonds. Overall, the proceedings reflect a balance between accountability and second chances, with the court prioritizing community safety while still offering rehabilitation opportunities where appropriate.
Mr. Ruba, you were placed on probation for racing on a highway. It has now come to my attention that you have now violated this probation. Is it true or untrue?
True.
Okay, I'm now going to revoke your probation and reform the judgment. It will now reflect as a conviction on your record. The agreement is 30 days in jail with credit for the 1 day that you have done. I am allowing you to turn yourself in April 18th, 2025 by 6 p.m. If you fail to turn yourself in, we will have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. Do you understand? If you are someone who is perpetually late to everything, this is one of the worst things, because if you arrive at 6:01, they will not take you and it will not go well for you. Do you understand?
Yes, I understand.
All right. So is it true or untrue that you violated your probation?
Sir,
It's true or untrue? It's true. All right. I'm going to find if it's true. Do you have a copy of the motion? Which one are we going with? Is it the one failure to do the effective decision making? I think so, Judge. Yeah, let's do the effective decision making. All right. All right. Mr. Rubio, I don't know if DPS is going to suspend your license. If you don't have a license, do not drive. If you don't have a license and liability, don't drive, because if you get into an accident and you maim someone, they're going to come after you for $50 to $100,000, and then you're going to be in the hole forever. You understand? All right, good luck.
Thank you, Judge.
Thank you.
Can I get him over here?
You are Lawrence Alawar. Mr. Alawar, you're charged with possession of a controlled substance. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
I'm sorry, at the last.
Alawar, please.
On March 24th, 2025, at 5:40 PM, officers were flagged down by a business owner at 8920 Gulf Freeway. The owner of the business stated that the defendant did not have business to conduct at the location and wanted to have a trespass warning against him from that location. Officers made contact with the defendant, leading against the vehicle with the front driver door open. Officers observed the odor of marijuana emanating from the vehicle. Probable cause search was conducted, and officers found an empty cigarette pack with pills, which, based on the color and markings and the officer's training experience, believed to be Xanax. Officers weighed those to be 0.53 grams. The defendant did not have a prescription for the Xanax. The defendant stated he's the owner of the vehicle and he's the sole driver of the vehicle. The defendant stated he had just bought the vehicle but did not change the title to his name, and he did not know anything about the pills.
Got it. Mr. Alawar, I'm going to find that there's sufficient probable cause to go forward with the case. Have you looked up his license, see if he has a valid license?
And I don't see a DL number on file.
If you do not have a Texas driver license and liability insurance, you're not allowed to drive. Do you understand? You will be signing an affidavit with me today promising you're not going to drive without either. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? You're not to go back to the business that's listed in this place. You're not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you have a drug or alcohol problem, I'm going to address it for you, and I promise you're not going to like the way that I do it. Do you understand? Mr. Alawar, do you have the ability to hire a lawyer?
No.
I'll have you, Deputy Miranda's going to give you an application. I'm going to have you fill it out. I need to know everything about you to see whether you qualify for an appointed lawyer. If you do, I'll provide your lawyer today. Don't pick up any new cases. Otherwise, it's not going to go well for you. Do you understand? Okay, Deputy Miranda, do you mind? Thanks.
Judge, is that free-for-all bond conditions?
No, he's going to be monitored. David Gonzalez. David Gonzalez, you're charged with tampering with the government record. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 24th, 2025, officers were on patrol in East Alden Management District in Harris County, Texas. Officers conducted a traffic stop on a motor vehicle that failed to display a license plate. Upon approaching the motor vehicle, officers observed a temporary tag that expired on 10/29/2024. The defendant was identified by his APHIS mugshot and SPIN number. The defendant stated he knew the temp tag presented did not belong to the motor vehicle. Officers concluded that the defendant knowingly presented a record with his knowledge of both. Defendant did not have an ID on him. TCIC searched the tags, came back to a different motor vehicle. Officers discovered the vehicle was salvaged and should not be operated on a motor vehicle. The vehicle then shown on the vehicle registered in South Carolina. Temporary tags that were displayed were for vehicle registered in Texas.
Okay. Did you run his license? See if you have a license. Please.
That's eligible, Your Honor.
Mr. Gonzalez, you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You must maintain car insurance. If I find that you're driving, you don't have car insurance, or you don't have a valid license, I will revoke your bond and put you in jail. Do you understand? Do you have the ability to hire a lawyer, sir?
No.
Okay, I'll have you fill out an application to see whether you qualify for an appointed lawyer. I need to know everything about you, and I'll take a look. We're going to have you sign documents here promising us you're not going to drive without a valid license and insurance, and after that, I'll take a look at your application. If you want to head on over to Deputy Miranda, he'll give it to you, sir. You are Josue Ibarra.
Yes, sir.
Mr. Ibarra, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Sit under 21 with Your Honor.
Okay, is that all you have?
I mean, Your Honor, it's on it's,
Officers were on 3/24/2025. Officers were on routine patrol with witness. Witness stated to officers that he observed a defendant assaulting a female in a apartment complex. Witness told officers that the witness saw the defendant displaying fire towards the female. Officers located defendant while the defendant was yelling at the female. Officers told the defendant to lay on the ground. Defendant stated he did not have any weapons on him. Officers conducted a pat down. Defendant felt a bulge in the defendant's ankle. Officers recognized this to be a firearm. Officers retrieved the handgun from the defendant. Female advised officers that she was not assaulted. NCIC TCIC check revealed the firearm was reported stolen. Officers observed that the defendant was previously arrested, also previously done.
Do they take?
They took.
Okay. Mr. Ibarra, I'm going to find that there's no probable cause to go forward with the case. How old are you, sir?
18.
How much? How
18.
18?
Yes, sir.
God forbid you have a weapon and you do something where you create irreparable damage, like use it in a situation. You need to be very careful in this life. You only have but one life. You have a gun and you use it and there's something wrong, your life could change in a moment's notice. Do you understand?
Yes, sir.
Very careful. Right, just hang tight for me, will you? Listen. Thanks.
I'm from Galveston. Palm trees everywhere, so there's roaches everywhere.
Right, yeah.
My brother would say, "What's that? What that roach?" Because I would scream, and I go, "Me?" He goes, "Okay then. Why are you afraid?" I'm like, "Okay." So I learned. Saquen las manos del bolsillo. Nomás escucho la pregunta. ¿Ustedes?
You are Guillermo Vasquez.
Guillermo
Vasquez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you have done. You need to understand that you're making a lifetime decision today. This DWI will now go on your record. What we are doing today, from now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. So if you're not in this country with permission, you do that kind of time, I can almost guarantee that you will get an immigration detainer. Do you understand?
Yes.
You give up a lot of rights by entering into this agreement. You give up the right to have a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you can never take it off. Is this what you want to do?
¿Qué desea hacer? Esto es lo que usted desea hacer.
Sí, sí, sí.
Yes, yes.
Sí, sí, sí.
How do you-
Yes, yes.
The offense of driving while intoxicated, guilty or not guilty?
Culpable.
Guilty, guilty, guilty.
When you guilty,
Te voy a ir con
all the
tu
agreement. I want you to understand, Mr. Vasquez, that if you're ever pulled over
Si usted lo para,
from now in the future, first thing an officer does is they're going to look at your record. If they see that you have a prior DWI, they roll to your window and they smell alcohol, it's probably not going to go well for you. So I would never, even if you've had a sip of alcohol, I wouldn't get into a car.
No, no,
te metas en una-
no.
Your lawyer is asking me to waive the mandatory fines and fees. That's around $3,000 to $4,000. I will do it because this is his first offense. If you come back here with a second DWI, it's $6,000 of fines and fees and a minimum of 30 days in jail. So get a clue. Do you understand?
¿Usted lo entiende?
Sí, lo entiendo.
Yes, I understand.
Good luck, sir.
Buena suerte, señor.
Gracias.
Thank you.
Dave, can we get a nollie on that second case?
Yes, ma'am.
Good morning, Mr. Sheriff.
Morning, sir.
How's jail?
I don't like it.
You know, you failed to appear 2, if not 3 times for these cases. Listen,
Okay, I'm sorry.
all I'm trying to tell you is that when you appear for court, good things happen. We have such reasonable prosecutors here. All you have to do is show up, and 9 times out of 10, good things happen. But when you fail to appear repeatedly, you now are deemed a flight risk. This is what happens. You need to understand one more thing. As a result of what we're doing today, from now on, you are facing a minimum of 30 days in jail for any new cases that you pick up here. Do you understand?
Yes, sir.
You're charged with 2 cases. You're charged with terroristic threat of a family or household member. You're also charged with criminal mischief. The plea bargain agreement you have worked out, they're going to dismiss the criminal mischief. They're also going to reduce your terroristic threat to a Class B. So now you're facing only 180 days and or a $2,000 fine. $2,000 fine. You've worked out an agreement. They're offering you 13 days in jail with credit for the 13 days that you have done. By pleading guilty, like I said, this will reflect as a conviction. Do you understand?
Yes, sir.
You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this. Is this what you want to do?
Yes.
How do you plead to the terroristic threat? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to withhold, or I'm going to find you guilty, send it to you to the agreement. The only other thing I'm going to tell you is that whatever you did to pick up these cases, I would be very careful, because if you continue with the same course of conduct, it's very possible they charge you with a more serious offense. All right?
Yes.
Good luck, sir. And next time, show up. All right. Take care. You are Javier Guevara.
Yes.
Mr. Guevara, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you have done. You need to understand that you're making a lifetime decision today where this DWI will be going on your record. It will be there for the rest of your life. It's even there after you die. This is important because if you get pulled over in the future, the first thing an officer does is they look at your record. And if they see that you have a prior DWI and they go to your window and they smell alcohol or they smell anything funky, it's probably not going to go well for you. And what we're doing today, from now on, you're facing a minimum of 30 days in jail. Do you understand?
Yes.
Even if you have a sip of alcohol, I wouldn't get into a car because it is a humongous risk. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen or possible facing consequences, you can be deported, excluded from the country, denied naturalization. Under federal law, you give up the right to appeal. That's why I said, once you plead guilty, it goes on your record, it will be there forever. Knowing all this, do you still want to do this?
No. Sabiendo todo, quiere seguirte. Viendo toda la información que le dio, pues quiere seguir. Yes.
Speak to the offense of driving while intoxicated, guilty or not guilty.
Guilty.
One more thing you need to understand, Mr. Guevara. DWI is big business in Texas. There's a $3,000 surcharge that would normally apply to you now as a result of you pleading guilty. And if you don't pay it, every $100 you owe, you sit 1 day in jail. I will waive that for you now because we all make mistakes. But I'm telling you now, if you continue to make mistakes where you endanger my public, the next DWI, it is a $6,000 surcharge. And like I said, if you don't pay it, $100 that you owe, you sit 1 day in jail. Do you understand? If you want to get lit, take an Uber. I'm going to suspend your license for 90 days. Do not drive until you get a license. Good luck, Mr.
In cases involving addiction, repeated DWIs, and probation violations, how does the court distinguish between punishment as deterrence and intervention as rehabilitation? And is there a measurable threshold where one clearly becomes more effective than the other?
Starting with the state.
John Denver, City. Jose Ceja for Mr. Alfaro.
Okay. Are you in on this as well?
I'll tell you. Plea jurisdiction on behalf of the state of Texas here.
Got it. Okay. So for purposes of the record, we are here. Today is set for a dispositive motion to suppress on this DWI second. And we are all in agreement that it is a dispositive nature. So if state loses, you dismiss. If you lose, you end up pleading, correct?
Right. And I think we already have the plea worked out, which is a reduction to DWI first probation.
Okay. And Your Honor, that was a prior deal with the prior prosecutor that I'm honored.
You're okay with it?
I'm honored.
Okay. You said you had some stipulations that you wanted to go over.
Yes, Mr. Davenport and I have some stipulations regarding to the relevant times, just to speed up the testimony.
Okay.
And I think he's got them written down. I'm not sure if he wants to read them into the record.
You mind?
Yes, sure.
Please.
At 3:40 a.m. on July 7th, the officers arrived on scene. At 3:44 a.m., the officers made contact with the defendant. At 3:46 a.m., the defendant was detained and placed in the officer's vehicle. And at 4:30, Officer Rohr begins the DWI investigation at the station.
You said at the police station,
Yes, Your Honor.
so there's no investigation on the scene.
There is no DWI investigation on the scene.
Okay. So it's your motion.
I don't know if the state is stipulating that this was a warrantless arrest. I mean, if not, then I can just call the officers and establish that.
You don't stipulate that it was a warrantless arrest.
Okay. All right. Ready?
Yes, Your Honor.
Okay.
And what if the state calls Chad Johnson?
Do you mind grabbing? Is he in the courtroom or is he outside? Please come up to the stand and raise your right hand to be sworn. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay? Please mind taking a seat. If you don't mind, please speak loudly, clearly. If you hear the word objection, just stop until it's addressed, and then you may continue. Okay?
Yes.
Okay. Okay, the floor is yours.
Can you please state your full name for the record?
Chad Johnston.
And what do you do for work?
Employed by the Pasadena Police Department.
How long have you been doing that for?
6 years.
Do you ever have any specialized training and experience for that?
That's the police academy.
Can you kind of briefly describe what that training involves?
Police academy?
Yes, just
Penal code, transportation code, CCP, DWIs, stop stack, building clearing. Basically anything that we could use on our government control.
And do you have any other experience prior to working at Pasadena Police Department?
In law
enforcement, yes.
Yeah.
And approximately how many DWI investigations have you?
I'm sorry, repeat that.
Approximately how many DWI investigations have you been a part of in your career?
Hundreds.
And do you recall a particular DWI investigation you were a part of on July 7th, 2024?
Sir.
Specifically, how did you come to be involved in the incident we are here for today?
Our dispatch received a call for service while a subject passed out at a intersection on the way.
Can you clarify what you mean by passed out?
Subject was inside his vehicle in a lane travel, asleep at the driver's wheel.
And what did you see when you got there?
Once I got there, their vehicle in the number 2 lanes for eastbound traffic on Southmore, stopped. Driver was slumped over, asleep with loud music. He initially started with flashing our flashlights on him, banging on the window. That was unsuccessful. It got to the point where me and my backup officer began rocking the vehicle for several minutes before the defendant woke up.
And did these facts at the time, did they indicate or raise your suspicions as to any particular crime that might be occurring?
Possible, yeah.
Why is that?
I mean, normally people do not fall asleep at the wheel while driving a motor vehicle, especially with their foot on the brake and the vehicle still in drive. And then if someone does fall asleep, which has happened in the past, they usually wake up pretty easily and don't need officers rocking the vehicle from side to side in order to wake them up.
So you eventually woke up the defendant, correct?
Yes.
And what did you do after that?
Once I woke him up, he took his foot off the brake and rolled into my backup officer's marked patrol vehicle. Then once he was stopped in the patrol vehicle, he got him to open up the door. I turned the vehicle off and placed it in park, got him outside the vehicle.
And when you got him out of the vehicle, did you notice anything specifically about it?
I smelled a strong odor of alcoholic beverages emitting from his pregnant person, and he had slurred speech.
And what did you do next?
I requested a DWI task force officer come to the scene if one was available.
And those signs that you said you observed when you made contact with the defendant, based on your training experience, what does that indicate to you?
Those are signs of intoxication.
You said you contacted a DWI officer, and after that, what did you do?
He was not available. He was occupied bail. Due to the vehicle being in moving line of travel, I arrested the driver for impeding the flow of traffic and transported them to the jail for the traffic offense and for the DWI officer to conduct a DWI investigation.
So you said earlier how many DWI investigations you've been a part of, but how many DWI investigations have you taken all the way through?
Very few. If I were to guess, probably less than 5.
And about how long would you say it takes you to complete a DWI investigation?
It would take me several hours.
And where was the scene in relation to the police station?
Block and a half away.
And how long did it take you to drive from the scene to the police station?
Less than 5 minutes.
And can you just clarify, why did you decide to move the scene to the police station?
There are several reasons. One, it's safer to conduct the investigation in a controlled jail than it is to conduct a DWI investigation in the middle of the roadway, where anyone can come by, get hit or cause an accident, get involved in an accident. Conditions are better, flat, even jail floor as compared to roadways where the I'm in the ground or anything like that. And then also, our DWI task force officer was occupied already, was unable to make the scene and requested that I meet with him at the jail.
Take past the loose, John.
Hold on a second. You said when he got out of the car, he stumbled back or crashed or something?
When he woke up, he took the vehicle was in drive with his foot on the brake. So once he woke up from us rocking the vehicle, he took his foot off the brake and rolled into my backup officers.
So it rolled in, it actually crashed into the other car?
Yes.
Okay, all right. That's the only thing I wanted clarification. Okay.
May I proceed?
Please.
Good morning, sir.
Morning.
So can you describe in general your role in this investigation?
I was the first officer on the scene and I was one of the dispatching and responding officers to it.
Okay, and fair to say that he was in pretty deep sleep, right?
Sure.
And at the scene, very little time was spent with Mr. Alfaro, is that right?
Yes.
Okay, now, you said that you've done approximately 5 DWI investigations?
Yes, but that's what it was.
Okay, but you've done your NHTSA training?
Yes.
And you know that the second stage of the NHTSA training is called the personal contact stage, right?
Mm-hmm.
Do you recall what that is?
I do not.
Okay. You know that in any investigation, it's important to spend time with the person that you're investigating and try to distinguish illegal from legal behavior, right?
Absolutely.
And in kind of big picture terms, that's one of the things that the NHTSA manual teaches you how to do, right?
Mm-hmm.
Is that yes?
Yes.
Because it's not illegal to drink and drive. It's only illegal to drink and drive while you're intoxicated, right?
I'm not necessarily having to drive my belt and detainer and other violations as well.
Well, we can agree that in not all.
About DWI, then yes, I would agree with you.
Okay. In general, not every time that somebody drinks after having consumed alcohol, not every time are they committing a crime, right?
Sure.
Okay. Now, in this case, you were dealing with somebody who was deep asleep and was roused out of sleep, right? And it wouldn't be surprising if that person exhibited things like red eyes, right?
Yes.
Yes, it would not be surprising.
It would not be surprising.
Okay. That they appeared maybe a little bit disoriented, right? And you say that his speech was slurred, but you had never met Mr. Alfaro before, so you don't know how he normally talks, right?
Yes, sir.
Okay.
I know what slurred speech sounds like.
Okay, but would it surprise you that especially on the station where the audio is more clear, his speech doesn't appear slurred at all?
That would surprise me.
All right. So in the time that you spent with Mr. Alfaro at the scene, that wasn't enough to distinguish whether the symptoms were from alcohol intoxication, possible alcohol intoxication, or just being roused out of a deep sleep, right?
I will not know. That's why I'm arrested for DWI right there.
I understand that, but in general, after such a brief amount of time, that wouldn't necessarily be enough to convince yourself that this is just a person that I've woken out of a deep sleep, right?
With other factors, I would disagree, but I mean, there's a possibility.
All right. Did you write an offense report in this case?
I wrote the supplement report.
One moment, Judge. Judge, may I confirm with the prosecutor for a second? Okay. Your offense report actually doesn't say anything about arresting him for impeding a roadway, does it?
My supplement does.
And Officer Rohrer, who was the lead officer in this case?
Officer Rohrer was the one that worked the DWI investigation.
Okay, and it was his understanding that the scene was being moved to the scene to continue the DWI investigation. Is that right?
Objection, Your Honor, speculation.
If you know.
I don't know what Officer Rohrer put in his report, but I'm not going to tell you what was in his report.
That's the witness.
Anything further?
Yes, Your Honor. Briefly, thank you. Officer, was this a public roadway?
Yes.
And were there any other facts that you said it initially that because of the defendant being asleep, you had suspicion of a DWI detention? So were there any other facts that gave rise to further suspicion of a DWI in the course of your
In my whole encounter?
Yes.
I mean, there was the strong of the alcohol and from him. I spoke with him and asked him if he had anything to drink, to which he told me he had a few. So he had admitted drinking, smelling on him, his sort of speech.
Say that's the one, John.
Nothing further, Jeff.
Someone mentioned something about an open container. Was there an open container or no?
No.
No. Okay. All right. You're excused. Subject to recall, anyone?
Subject to recall, please.
Okay. If you don't mind, please just waiting outside in the jury. Step. Okay. State any other witnesses?
Yes, Your Honor. The state calls Brian Rohrer to stand.
Great. Do you mind grabbing a picture?
All right, witness has not been sworn in.
All right. Deputy Work, if you don't mind coming up to the witness stand and raising your right hand.
Sir.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, please do take a seat. If you don't mind, to speak loudly, clearly. If you hear the word objection, just stop until we address it, and then you may continue. Okay? All right. State, please.
Thank you, Your Honor. Can you please state your full name for the record?
Brian Charles Ward.
And what do you do for it?
I'm a police officer.
How long have you been doing that for?
About 4 years now.
And do you have to have any specialized training to do that?
Yes, sir.
Can you briefly describe that training?
The basic police officer's course is about 9 months of specialized training as mandated by TCOL, as well as I'm a member of our DWI task force as well, which is further specialized training.
And what kind of specialized training do you have to have to be part of the DWI?
We would be a part of our DWI task force. You have to have basic SSD, standard skills Friday tests. You also would highly encourage you to a ride course, as well as you have to be certified as a program engine expert within 1 year of your posting.
And how long have you been a part of the DWI task force specifically?
About 1.5 years.
And over what years, one as a police officer, how many DWI investigations have you been involved with?
I'd say at this point, probably upwards of 150.
And generally speaking, I know everyone's different, but how long does it take you to complete a DWI investigation?
Generally about 2 to 3 hours.
And do you remember, do you recall the incident that we're here for today that occurred on July 7th, 2024?
Yes, I would.
And can you explain how you became involved with that?
There was a call service, officers went out, found the reason was people stopped in the roadway. They had reasonable conceit to believe a DWI investigation needed to take place. Couldn't make it out to the scene, so the subject was actually transported up to our top room to meet.
And upon contact with the defendant, what did you notice?
I noticed eyes were red. Also detected odor of alcoholic beverages and some slurs.
And what did you do next?
Next was going into the DWI investigation, which would be the Miranda's questioning and then sobriety tests.
Do you recall the specifics of your investigation as far as the scenarios for sobriety test?
As far as the specifics in clues specifically for the assessee?
Generally, yes. If I were to ask you about the clues that he exhibited, would you recall that?
I would probably have to reference the report again.
So just have one moment, Your Honor. Sure. Please do. First witness, Your Honor?
Yes.
You recognize? Go ahead.
Yes, I do. And when it's my official report from the United States.
Related to professional recollection. Officers, your recollection refreshed?
Yes.
So you made contact with the defendant and you said you began to carry out your investigation.
Sorry, say that again.
You made contact with the defendant and you began to carry out your investigation. What was the first step in that process?
So excuse me, I'm sorry. First step of the process would be an interview of the subject.
Okay. And what did you learn from that interview? Okay, we're going to skip that. We're going to go to the standardized field sobriety test. What was the first standardized field sobriety test you carried out?
Horizontal gaze disastrous test.
Okay, and what is that test?
That test checks for the involuntary jerking of the eyes.
Okay. And what were the results of that test?
The result on that were 6 out of 6 validated groups.
What are those 6 clues?
The first one is a lack of smooth pursuit. Then following that is a distinct and sustained nystagmus to maximum deviation, and then the onset of nystagmus prior to 45 degrees.
And it's fair to say that he hit all 6 of those clues.
That is correct.
And what does that indicate to you?
That would indicate the presence of a substance in this.
Would that indicate alcohol, a potential presence of alcohol in the defendant's system?
Yes.
And what did you do next?
Next was the walk and turn test.
Okay. And what is the walk and turn test?
The walk and turn test is one of the psychophysical tests, where it splits the subject's mental and physical capabilities to possibly give a intoxicated individual would have difficulty splitting those.
And what were the results of this test that you carried out?
On this test, I observed 2 out of 8 validated groups.
And what did you do next?
Next was the one-leg stand test.
Great. And what is the one-leg stand test?
Again, it's another psychophysical test. The testing the subject's ability to count while balancing on one leg.
And what were the results of this test?
On this test, I observed 0 of 4 validated groups.
And what did you do after that?
After that would be reading the subject EIC 24.
Based on the totality of the circumstances, were you able to form an opinion on whether or not the defendant was intoxicated?
Based on the totality of circumstances and the results of my investigation, I did form an opinion that he was intoxicated and had lost the mental and physical capabilities required to safely operate a motor.
State best of the witness, Your Honor.
May I proceed, Judge? Good afternoon, sir. Good morning, I should say. You wrote in your report that Mr. Alfaro was transported to the Pasadena jail for further investigation after he was detained at the scene. Is that right?
That is correct.
Okay, so it was your understanding that he was transported to continue the DWI investigation, correct?
That would be my part of the investigation, yes, sir.
Okay, he wasn't under arrest for anything else as far as you were aware of?
As far as I know, he was transported, he was placed under arrest for traffic offense.
All right. Now, you mentioned that it takes 2 to 3 hours to complete a DWI investigation. Can you break down exactly what goes into that?
So in those 2 to 3 hours in that estimation, I would be including initial contact of the subject, interview, observation, or possible interview of initiating officer, my interview with the subject, the SFSTs, as well as the collection of a forensic specimen and typing the report.
Okay, but really, when you're talking about an arrest, the relevant portion is usually much shorter than that, right?
That is correct.
So you're talking about maybe the personal contact stage and then the pre-arrest screening stage, right?
I'm sorry, I don't understand the question.
Well, I mean, the point at which you get enough evidence to confirm that somebody's intoxicated or disconfirm that somebody's intoxicated is much, much shorter than 2 to 3 hours, right?
Yes.
Because that takes into account booking procedures and things like that, right?
Correct.
Okay. Now, this wasn't a situation where there was an emergency going on, right?
No.
Okay. Even though you're the more experienced officer, Officer Johnson is actually certified to administer field sobriety tests and has done so in the past, correct?
That is correct.
Okay. There wasn't a language barrier or anything like that, right?
Not to my knowledge.
And in fact, the intersection where this all happened, I mean, there were parking lots, drugstore parking lots, places where DWI investigations are sometimes conducted, right?
Yes.
Okay. So, in other words, there was nothing to stop the DWI investigation from being conducted where it was there at the scene of the incident. Nothing that you can point to, is there?
As far as the performance of SFSTs, no.
So what was the reason for moving this investigation to the jail?
To bring him to a member of our DWI task force who is better suited to performance of the SFSTs and to provide a space more conducive to performance of the SFSTs.
Okay, but if you had wanted to, it could have been this, or if, not you personally, but if law enforcement in this case had wanted to, this investigation could have been pursued more diligently.
Objection, Your Honor, speculation.
Oh.
If there's a lot of sufficient space in a safe place, that again has sufficient space and level ground to perform the SFSTs, i.e. a space and level service more conducive to performing the SFSTs safely, then yes, it can be.
So it could have been done more diligently, correct?
It could have been possibly performed by the officer on scene.
Okay. Pass the witness.
Officer, approximately how long did this investigation take?
This investigation, in terms of interview and arriving at a decision of intoxication, I would say approximately 40 minutes.
And typically, are DWI investigations faster or slower if you or another member of the DWI task force conducts the investigation, rather than a member of patrol unit?
It is significantly faster.
Say pass the witness, Your Honor.
Nothing further, Judge.
All right, witness may be excused. All right, thank you, sir.
State anything further?
Just argument, Your Honor.
Okay.
Judge,
So hold on. You rest?
Yes, Your Honor, say this.
I'm going to admit a thumb drive with 2 body cameras and then the scene body camera. And I'm not going to publish this right now. I'm going to offer it as a part of the record. And I don't have anything to stick it with, but we can call this Defense Exhibit 1.
Have you seen this? Do you know what it is, State? And do you have any objection?
I mean, it's just body cam from the scene, we were in Your Honor.
Okay,
Actually,
all right. It'll be admitted. Defense one?
Defense 1, Judge.
Okay.
And with that, we rest.
Okay. Argument.
Thank you, Your Honor. Your Honor, the state offers three arguments here. First is that clearly under the traffic code, Officer Johnson had probable cause to arrest the defendant at the scene for the traffic violation. Upon arrival, the officer could clearly see that the defendant was parked in a moving lane of traffic in violation of traffic code section 545-363 and 545-1302. That arrest is clearly authorized under traffic code section 543.001. And after that arrest, once the officer had transported the defendant, then a separate DWI investigation took place, which is clearly legal and proper and does not violate any of the defendant's Fourth Amendment rights. And the alternative, Your Honor, the state would also show that the officer articulated sufficient facts to rise to at least reasonable suspicion that the offense of driving while intoxicated had occurred. The defendant displayed a strong amount of alcoholic beverages, was asleep in his vehicle, and took significant effort to wake up from the officers. Also, the time of night was indicative, and the other facts that the officer suggested, such as slurred speech and the other surrounding circumstances. Furthermore, moving the investigation to the police station and the subsequent time it took to move the investigation. Furthermore, moving the investigation to the police station and the subsequent time it took to move the investigation was reasonable under the circumstances and served a legitimate law enforcement purpose. That purpose was to give the DWI investigation to an officer that would be more efficient at running the investigation. This purpose, this is supported by prior case law in Belcher v. State, where, Your Honor, the Court of Appeals out of Fort Worth found that a 30 to 35 minute prolongment was reasonable under the circumstances for the express purpose of the officer handing the DWI investigation over to a specific DWI officer for the purpose of efficiency. Furthermore, Your Honor, the state in the alternative to that argument would also go to show that probable cause existed at the scene due to the totality of the circumstances and the signs of intoxication and the clear operational facts that the officer had at the scene rose to the level of probable cause for the officer to arrest the defendant for the offense of driving while intoxicated.
Can you come up real quick, Blaze? Come up. Mr. Damo, come up. Sure, on the record. As a lawyer, as a person who just works in general, I really take pride in what we do. You know, when we do stuff, we come prepared. This is not a joke, man. This dude that just came and testified now was a deer in headlights when you asked about the interview. Completely and wholly unprepared in every single way. So I don't give any credence to that testimony right there whatsoever. I mean, it's like, how are you going to come? This is not a joke. You know, we take this completely serious. You know, you come here, you can't even recite what happened. You can't even take 5 minutes to look at the damn report. You know, really. So that, no credence whatsoever. So what I'm going to do now is I'll take a look at the facts surrounding what happened on the scene, and I'm going to make a decision and see whether we go forward or not. But I'm floored how you're just going to come in and just kind of, here, let me just, you know, really, it's not a joke. It's a life on the line here. And I really take it seriously. And I'm just offended by it. So anyway, I don't need it.
All right.
Let me just take a look. I want to see that real quick. And then I'll have a decision here within a couple hours. Okay.
All right.
All right.
Thank you, Judge.
Thanks.
May we excuse?
Please.
Right.
All right, lawyers, let's go. Just don't, just, it is what it is. You know, it just.
Your Honor, throughout these cases, we've seen repeated references to prior history influencing present bond decisions. At what point does prior criminal history outweigh the constitutional presumption of innocence in a new case, particularly when the current allegation is procedurally recent or factually disputed.